I'm going to turn it over very quickly to one of my favorite trainers, ADA specialist, Sashi Nisankarao. Sashi has been with us, I can't really call her our newest employee anymore, but she is our newest member still of the ADA Center. She's been with us now, though, for about 2 years. I can't believe time has really flown that fast. And she's, in that time, she's provided a lot of ADA technical assistance and training, both on the consumer and business end. So she brings with her a lot of experience to the table. Sashi, I'm going to go ahead and turn it over to you.
Thank you so much, Marissa. Good morning, everyone. I wanted to thank Melanie for putting this together, and Roberta. And like Marissa says, we really value our partnership with the university, and it's awesome that you guys have kicked off this series of webinars for National Disability Employment Awareness Month. And getting on topic with what we're going to talk about today, we are going to learn everything there is to know about ADA and employment. It's going to be a very sort of sweeping overview of the topic of employment because there is a lot of nuance, and so in this series we'll touch on a lot of different topics, and then in the next 2 webinars that you guys get throughout October, we'll talk. George and Diego, my colleagues, will inform you guys about more specific issues. So with that, let's get to it, Marissa. Go to the next slide. Okay, so we put up a little disclaimer before all of our trainings that we do. We do not provide legal advice and legal services here at the Southwest ADA Center. Even though some of us are attorneys, we are not your attorneys. That being said, though, feel free to contact us if you do need technical assistance, because that's what we're here for. Okay, let's get on to our presentation. Okay, so the ADA in a nutshell. Now, the Americans with Disabilities Act was passed in 1990, so it'll be 30 years old next year. Still a relatively young civil rights law, but the goal of the ADA is to sort of comprehensively cover non-discrimination, right? And so non-discrimination based on disability. It prohibits discrimination based on somebody's disability status. And like I was kind of hinting at earlier, it takes an individualized approach to the way that we apply the ADA, meaning that you are evaluating how the Americans with Disabilities Act applies, and even whether it applies on an individualized sort of case-by-case basis. So keep that in mind, that no 2 people, even with the same disability, are going to present themselves and their situations in the same regard. Next slide, please. Okay, so like I said, the ADA is a comprehensive law, which means it covers a lot of different aspects of life. So the one we're going to talk about today is employment, Title I. Title II covers state and local government entities. So this kind of applies to the university as a whole, because you are a state and local government entity that provides services to both your students and to visitors. And so partially the university would fall under Title II. Title III, we're talking about public accommodations. So these are going to be like restaurants, hotels, places of business, basically. Title IV, we talk about telecommunications. This is going to be providing TTY services for the hearing impaired. And then Title V is dealing with sort of miscellaneous topics. This is going to be dealing with like legal remedies under the ADA, attorney's fees, things like that. But like I said, today we're going to really hone in on Title I, employment. Next slide, please. Okay, so let's talk about the scope of Title I of the ADA. So it applies to private entities with 15 or more employees. So this is going to be like, a corporate office. So like my example is Dunder Mifflin Paper Company in Scranton, Pennsylvania, which is from one of the best shows ever on TV, The Office. That Dunder Mifflin Sabre Company would be considered a Title I entity because it's a private company that employs 15 or more employees. But then it also applies to all state and local government employers. So that's where you guys would fall in. As a university employer, you are a state and local government entity, like we talked about earlier. So you guys would fall under the second prong of the scope of Title I of the ADA. Next slide, please. Okay, so what is the intent of Title I, right? Like why was Title I drafted to prevent, and this is the reason why, is to prohibit discrimination against qualified individuals on the basis of disability. Well, qualified, what we mean is that they can do their job, basically, right? So as long as they can do their job, regardless of, whether they receive accommodations or not, they're qualified. And, it just happens to be that they have a disability. And also the purpose of Title I of the ADA is to give these qualified individuals with disabilities equal access throughout all the different phases of employment. So, here I just listed some, but if you think about it, really, like, there are just so many different phases in a timeline of one single job, right? Like the minute that you find a posting and you fill out an application, you are entering that employment, the employment realm. And as you move through the different processes throughout employment, from filling out that application to going in for an interview, to going through the recruiting process, to being hired, to starting your job, to participating in any of the employee benefits programs, to being promoted, to being evaluated for your performance standards, even all the way through termination, right? That is the life of one job. And so what the ADA, and specifically what Title I does, is really say that at any one of these phases of employment, we are going to give people with disabilities and people without disabilities equal access to participate in all of those phases of employment. Next slide, please. So we're just going to kind of switch gears just very briefly to talk about different laws that also apply to the university, right? So the first one that we're talking about is another federal law aside from the ADA, and this is Section 504 of the Rehabilitation Act. And it basically does the same thing, prevents discrimination based on disability, and it applies to entities that receive federal financial assistance, federal funding, right? And certainly the university, through different programs, does receive federal funding. And so there are 504 implications and 504 standards to keep in mind as a state university. Next slide, please. And then we're going to switch to your state law. So in Arkansas, it's called the Civil Rights Act, and there are specific employment provisions in the Civil Rights Act as well. And here, so if you remember in the ADA, right? In the ADA, we're talking about private employers that cover 15 or more employees. And what state law's responsibilities is to cover gaps. Where the federal law doesn't cover something, the state law will come in and say, hey, we're going to be a little bit stricter, and we're going to really sort of narrow the scope and the application, and sometimes maybe even broaden it. It depends, but really it's a stricter application of a federal law, usually is what a state civil rights law does. And in this case, the state law in Arkansas goes as far as to cover all private employers with 9 or more employees. So we lower the threshold a little bit. And the overall goal of the Arkansas Civil Rights Act is, once again, to prevent discrimination based on somebody's disability. And there are specific types of disability that the state law mentions. So, it's just, I thought you guys should be aware of the state law implications as well. Next slide, please. Okay, so now we're going to switch back to the federal ADA law. We are going to be talking about the definition of disability under the ADA. And the definition actually is meant to be broad. It's meant to be not too technical. It's a legal definition. It is not a medical definition. So we are not talking about the definition of disability, for example, like under a Social Security regulation law. We're not getting very technical, and we're not getting very medical with this definition. So the definition is having a physical or mental impairment that substantially limits one or more major life activities, right? So that's one definition. Second one is or having an impairment, having such an impairment, or having a record of such an impairment. And we'll we'll flesh out what these second two definitions mean. And the third one is being regarded as having one of these impairments. So, on the face of it, yes, they are pretty broad, but they are intentionally broad. And so we'll see why in just a second. Next slide. Okay. So the ADA Amendments Act was, like, the ADA was passed in 1990, as we discussed earlier. What happened with the ADA Amendments Act in 2008 was the federal legislature sort of felt like courts were too strictly interpreting what the definition of disability meant, which means they were getting too technical and they were focusing too much on whether somebody had a disability and not on the discrimination aspect of the ADA, which was originally the intent of the ADA. So basically, that's the reason behind this language in the definition of the ADA. And so this is why you don't consider the effects of, like, mitigating or remedies that people use, right? Like wheelchairs or medications and things like that. Really, you're just considering how the disability impacts the person. And so that's, that was sort of to caution courts away from saying, like, hey, let's strictly focus on whether this person has a disability or not. And so, it's just, I kind of put this in here so that when there are reasonable accommodation requests and things like that that come through, that you as a university focus on how somebody's condition or how someone's impairment is impacting them as opposed to the condition itself. Next slide, please. Okay, so major life activity, right? And the ADA sort of says that it needs to impact one or more major life activities. So it could be just one. It doesn't have to be, multiple ones. And it's a non-exhaustive list. There's just so many major life activities out there. And we'll show you some of them, in the next slide. But really, we can talk about, like, bodily functions. There's a myriad amount of them. So really, let's go to the next slide and we'll see examples of major life activities. So here we go. It could literally be anything, right? Like seeing, hearing, breathing, eating, some bodily functions, right? So even like reproductive, like being able to reproduce, could be considered a major life activity. So if you are dealing with, like, infertility issues and seeking treatment for it, could potentially be covered under the ADA. But this is just some examples. It's not all of the examples of what a major life activity is. But you can see from this list how purposefully broad the definition was meant to be. Next slide, please. Okay, so here we're talking about bodily functions, like we mentioned earlier, and this would be, like immune system functions or cell growth or digestive function, just things like that. I mean, really, like, once again, this is definitely not an exhaustive list, but you can see that this list kind of covers all the different major organ systems and major functions that our bodies are doing even subconsciously. We don't even think about it. Next slide, please. Okay, so so here we're talking about, sorry, my computer's being a little weird. Here we're just talking about some conditions that are considered to be disabilities under the ADA. And some of these you'll see are more obvious, right? Like blindness and deafness. And then some of them, the more common disabilities actually in the country are the hidden disabilities, the ones that you can't immediately tell whether somebody has that disability, like diabetes, right? Diabetes, very common disability in America. But you probably wouldn't be able to tell whether somebody has diabetes. But if you just take a look at these some common and some non-common list of conditions, I mean, this again is a very sort of non-exhaustive list. There's just thousands of disabilities that could be covered under the ADA. These are just some of them. Next slide, please. Okay. And so now we'll talk about kind of the second and third of the definitions that we looked at a few slides ago, right? So a record of a disability, right? This is kind of the same definition as actually having the disability. It just may be something that's a little bit intermittent. So even like if you are a cancer survivor, you might have multiple experiences with cancer. Cancer, you might be in remission, and then the cancer may reemerge, and so you may be dealing with cancer treatment again. But it is to say that you have a record of disability, a record of such an impairment, and there might be times where you're seeking treatment actively, and there might be times where you are, where you're in remission. So the definition kind of changes when we talk about being regarded as having a disability. This is basically talking about, like somebody's impression of somebody who has a disability, right? And so it may or may not be confirmed whether this person has a disability, but in the workplace, it might be that other people are perceiving them as having a disability. There used to be a time limit, like a time threshold on how long somebody would have had to have dealt with this disability. We've since done away with that 6-month time period. So it's just to show that there's a slight nuance to the regarded as prong versus the having a record of prong of the definitions of the ADA. Next slide, please. Okay, so we're gonna kind of switch into the hiring aspect of employment, and so now we're getting into the different phases of employment. So, even within hiring, right, there's different little mini phases of hiring. So here we're talking about pre-employment. So you need to accommodate somebody, right, as soon as they are applying for a job. So even in the pre-employment phase, there is an obligation once somebody tells you that they have a disability to accommodate them if they're requesting accommodations. What you may not do is you may not make any inquiries about the person's disability status, and this would be during like recruiting and screening and hiring. So, unless somebody comes out and tells you and discloses that they have a disability, you may not make any kind of inquiry into whether they have a disability or not. And then this third bullet that we have here on medical inquiries, right? no medical inquiries during the pre-employment phase. And this would be if you have some, I mean, this would definitely be like if you have some kind of like manual labor job or something like that, and sometimes people will require like physical examinations and things like that. But really, you wouldn't be able to have um, these medical examinations to reveal whether somebody has a disability during the pre-employment phase. Let's go to. So yeah, let's go to the next slide. Okay. Sorry, a little confusion. Okay, so now we're kind of in that middle part of hiring, right, where there might be an offer that's been made, but the person hasn't started working yet. And this could take some time. Actually, there might be a few weeks even that lapse during this time. So you can do a little bit of medical inquiry here after a job offer has been made. And it's going to be, it's going to be, so basically the extent of the medical examination, the extent of the medical inquiry, right, has to be equally applied across all the different employees that you have in a job category, in a job position for that matter. And this is just to say that people who have disabilities are not undergoing extensive medical examinations or extensive medical inquiries more than their colleagues who don't have a disability. So if the inquiry ends up showing or it ends up revealing that the person has a disability because maybe they haven't disclosed that to you prior to the medical inquiry, then if you decide that the person, if it's revealed that maybe the person is not qualified to do that job, then you would have to show that you're screening out the person during this phase of employment because of job necessity or because of job relatedness and because of business necessity. So you really, this is going to be for the HR people that are listening to this, is document, document, document. So at all phases of the hiring process, document what kind of medical inquiries are made, what kind of disclosures are made by the employee or by the applicant, I should say. And then also, if it's revealed that the person has a disability after these medical inquiries and they are shown not to be qualified anymore, then document the reasoning behind why the person's been screened out. And you also have to show that if you are going to be screening this person, if you're going to be screening them out because they're not qualified, you need to show that the employer wouldn't be able to accommodate that person. And this is going to be a little bit more difficult because we'll see later on that there are a lot of common accommodations out there. And so once again, it's important to document the impracticability of being able to accommodate this employee if it's found that they are no longer qualified. Next slide, please. Okay, so now we're talking about somebody who actually has begun to work, and then so now we're talking about like accommodations, and like I mentioned in the previous slide, right? Accommodations are going to be just pretty much anything. So we'll see kind of examples of accommodations later on, but really these are things that managers and supervisors probably already do for their employees just very regularly that that they don't really think about as being accommodations. And like we mentioned earlier, it applies to the hiring process and to once people have begun work. Definitely accommodations need to be provided for people with known disabilities. But, we'll talk about kind of disclosing a disability and everything like that throughout the remainder of these slides. And then it's determined through an interactive process, and we'll kind of talk more about what the interactive process can be a little bit later on. And then we'll also talk about the kind of documentation that you as an employer may request of an employee during the reasonable accommodations process.
Okay.
All right. Okay. So, like we said earlier, right? The term reasonable accommodation is just super broad and could include just a number of anything. Most employers are kind of already doing a lot of the things that we will see a little later, but it's just the intent of a reasonable accommodation is just to allow somebody to do their job more effectively. And because the person is already qualified to do the job, the person has to be qualified to do their job under the ADA. Really, we're just saying, regardless of whether you have this disability, how can we allow this person to be more effective at their job? That's the question that the employer and the employee should be asking during the reasonable accommodation process. Next slide, please. Okay, so we kind of mentioned earlier, right, about disclosing whether somebody has a disability. And it's, this is kind of just some considerations to make. It's like, whether somebody would want to disclose their disability or whether they wouldn't. And this really goes to say that it's always the employee's choice whether they want to disclose their disability. And the employer wants to create an environment where applicants and employees feel empowered to disclose their disabilities, because they feel like once they do so that they will be accommodated. So most of the time, the reasons why people will not disclose their disability is because they fear that they'll be screened out, or they fear that they might be pushed out if they already are employees, that they might be phased out. So, it's a good idea for the employer to create an environment that says to the employee or to the applicant that that we are a place where you should be free to disclose whether you have a disability and not have the worry of retaliation or anything like that as a consequence. Next slide, please. Okay. And so, okay, here we're just kind of talking, we're going to, over the next 10 slides, we're just going to be talking about the 10 sort of reasonable accommodations concerns and different sort of nuances of reasonable accommodation. So we'll get into it with the next slide. Okay, so what is a reasonable accommodation? So we hinted at this earlier. It's just going to be any change in the environment or any change in the policy that is going to allow somebody with or without a disability to do their job more effectively, to enjoy equal access to different aspects of their employment. And like we said earlier, it applies to all the phases of employment. And we'll talk more specifically about interactive process and other aspects in the coming slides. Next slide, please. These are just some examples of reasonable accommodations, and you can see that it's another one of those lists that is non-exhaustive, and we can get really creative with the kinds of accommodations that we provide to our employees. And so that's where the original intent of the ADA comes in, which is you're doing this on an individualized case-by-case basis, and so you want to treat each request that you have individually. And so, yeah, just take a look at this list, and I mean, once again, these are pretty broad, non-exhaustive list of examples. Next slide. Okay, So the cost of accommodation, because most of the time when an employer is sort of reluctant or, just says that they cannot make an accommodation, a lot of times they will say that it's just too costly. And cost alone is not going to be the end all be all for the reason why an accommodation is denied. We need to think about all different considerations. But most accommodations are free, or not most, I should say about half of the accommodations are free, because they're probably things that people do already. And so, really cost is not going to be the deciding factor in whether an employer doesn't provide an accommodation. And then, when there is a cost associated with an accommodation, it's usually about $500. So, it's definitely cost is a consideration, but it's not the deciding factor, like we said earlier. So this is going to say that the employer is responsible for providing the accommodation and for the cost of the accommodation. And there may be some, tax incentives available, both federal and state. So it's a good idea for employers to make accommodations and to do their research on how best they can make those accommodations to benefit sometimes more than just the one employee. Sometimes it ends up benefiting multiple employees or all of your employees. So next slide. Okay. So who can be accommodated? So here we're talking again about the different phases of employment. So, applicants, as soon as they start to apply for a job, and then full or part-time employees are also qualified to receive accommodations. Seasonal and temporary employees are also covered under the ADA to receive accommodations. So the holiday season is coming up soon. So if somebody gets a job at a large retailer, just for the month between Christmas or between Thanksgiving and Christmas, even they would have certain protections under the ADA to receive accommodations if they have a disability. Trying to think if there's anything that we should cover here. This last prong right here, right, about performing the essential functions of their job. I mean, this is just to reiterate that the employee still needs to be qualified. So really, we're looking at first whether the person is qualified, and then how their impairment affects them. So that would give you the two big considerations to make when you're deciding whether somebody is protected under the ADA. Next slide, please. Okay. So how is the accommodations process triggered? So usually it's going to be upon the employee's request or upon the applicant's request, depending on what phase of employment the person is in. But it doesn't have to be something that's formal. It doesn't have to be something that's in writing. If you have an applicant or an employee who comes into your office one day or just casually says, I need help with something, I'm having trouble doing this, I can't seem to be able to do this, then that could also trigger the accommodations process and a request. And so it's a good idea to just be mindful and be aware, because we have so many conversations with our colleagues throughout the day, and we talk about so many different things, and so sometimes some of these might actually trigger accommodations requests depending on the nature of the conversation. So it's a good idea if the employee does put it in writing, because then it's documented, but they don't necessarily have to. It is okay for you as the employer to have a formal accommodations request process where there might be some paperwork to complete for a doctor if it's like a non-obvious disability, right? But the paperwork, just like when we were talking about medical inquiries, it has to be job related. It can't be something that's overly broad or vague and just like a fishing expedition. The paperwork needs to be sort of tailored to the scope of what this employee is doing as part of their job. So those are just some kind of considerations to think about when you're sort of triggering the process. And once you get a request, once you receive a request for accommodation, make sure that you promptly respond to the request. If it's going to take some time and you're waiting on a response from somebody else, keep the employee informed. Don't, try not to sort of, I don't want to say ignore, but just, I guess, keep them informed of like where the employee is in the process so that the employee feels like, okay, they're engaging me, they're keeping me in the loop. And the first thing that the employee wants out of the reasonable accommodations process is to feel like they're being heard. And so that's a good way of doing it, is just to keep the employee in the loop. Next slide, please. Okay, so can you ever deny accommodations? So this is when we're going to talk about undue hardship, the undue hardship defense. This is an affirmative legal defense. A lot of times you'll hear employers sort of say this term, not really understanding sort of the depth and breadth of the term, because it is kind of a loaded term here, undue hardship. So, you have, if you are going to say, no, we cannot accommodate this person, you really have to be ready to document why you can't do so. So if it's cost, you need to show how the cost is just going to, if it's going to alter the kind of if it's going to kind of alter the nature of the service or the job that the person is doing or that the business is providing, then you want to get ready to show that. There is no set dollar amount it's not like, oh, if an accommodation costs more than $1,000, then you don't have to provide it. There is no set dollar amount. That's why you want to be able to document specifically how the cost affects the company or the organization as a whole. You want to consider the overall resources of the organization. So it's not enough just to say, well, in our finance department, we only have this much in the budget for accommodations. If there's a way that you can dip into funds from other departments or from other sources of funding within your own department, then you might consider doing that. Which, once again, you would really need to sort of be able to document the reasons if it is the case that you can't do it. Another factor to consider is, and like we were kind of getting at this earlier, is a disruption in the operations. So is it going to create this, like, does it create a legitimate and concrete disruption? Because it has to be. It needs to be significant. It needs to be legitimate. It can't just be like a normal run of the mill type of speed bump in the kind of operations that you run as a business. And then, you want to think about, how else can I get this accommodation? And what other benefits do I have to providing this accommodation? And that's like what we were talking about earlier with the tax incentives. If you feel like you have already tried to accommodate this person, you're actively accommodating them, and this person might create still a direct threat to himself, herself, or to his or her fellow employees, this is where you kind of get into the safety concerns that a company may have. And this is where you get into direct threat territory. So direct threat is not just considering the potential threat that an employee or an applicant would have to him or herself or to other employees. it has to be a real threat. And the employer needs to have provided accommodations to this person. And even after doing so, the person continues to pose a direct threat to the work environment or to himself or herself. So it's just a consideration to make, because I think sometimes employers, based on certain kinds of disabilities that people have, might say, I don't think this is going to create a safe environment in our office or in our organization. But the diligent thing to do would be to show that the employer has made that accommodation first and then do a direct threat analysis. This last point is important. So we always say that the employee and the applicant, employee or the applicant, need to be qualified to do that job. If at any point the employer is considering, is making this consideration, the employer does not need to cut out certain essential functions to accommodate this person, because that goes to the question of whether this person is qualified in the first place, right? And that's not the intent of reasonable accommodations and of Title I of the ADA as a whole. It's to make sure that the person is and remains qualified at all times during the job. Next slide, please. Okay. So now we're getting at the interactive process. This is going to be sort of the heart of reasonable accommodations, and this is going to be the most important. This is going to be the most important part of somebody's reasonable accommodations request process. So it's really important that everyone involved, if it's HR people, if it's supervisors, are active and are keeping people in the loop and are staying in communication regularly, because really this is where reasonable accommodations are made or broken. So you want to give consideration first to the employee or the applicant who's making the request, because ideally they, having dealt with this for some time, right, having dealt with their impairment, they know what works for them. So you want to give deference and preference to the individual first and say, what kinds of things can we do to help you more effectively do your job? But sometimes they may not know, because it may be a newly acquired disability. And so it's just a good idea to start with that employee first, and then you open up the lines of communication and figure out, okay, well, if you're maybe not fully aware of all the things available to you, then let's do some research and let's work together to find out which accommodations are going to work best. The most expensive accommodation is not always the most effective accommodation. This is certainly true. There are going to be some low or no cost accommodations that you can provide that actually might have a larger and more lasting impact. So it's just something to keep in mind, especially with like free apps and things like that, like OCR apps for download, where it turns images into PDF documents that can be read aloud, like things like that. Those are often free. And so those are going to be low to no cost options. So like we're saying earlier, this is a very sort of individualized case-by-case approach. And so you need to think about all the different aspects and all the different factors that go into somebody's employment. So yes, you do consider the kind of disability somebody has, you consider the work that they need to do, and then you also consider where the job is happening, what kind of environment is this person working in, and how is the accommodation that we provide going to fit into that job environment. Next slide. Okay, so what kind of documentation can you request from an employee who may be requesting accommodations? So the employer may request accommodation about the person's disability, especially when it's maybe not readily apparent the reason, especially if the person has a hidden disability, right, where the employer may not be able to tell why the person is asking for an accommodation. That's when an employer is permitted to ask for limited documentation. So once again, can't stress this enough, the documentation has to be job related, right? And it needs to be consistent with business necessity. So when you guys, when HR professionals, when supervisors, when managers make these documentation requests to their employees who are requesting accommodation, be as specific as you can. Try to tailor your request to the kind of accommodation that the person is asking for and the kind of work that the person does for the organization. Okay, and that's kind of like what we were talking about here in the previous slide. Okay.
Sorry, my fault there.
It's okay. And so, so it's something to think about, because I think what happens is, because we hear from both employers and employees a lot for technical assistance questions that they have, a lot of times employees feel overwhelmed at the amount of documentation that they feel they need to provide their employer. And a lot of times employers feel like they are not receiving relevant documentation. So when they get something back from an employee, they're always saying, this doesn't really relate to, what we wanted or what we were looking for. So for everybody, it's a good idea to be more specific and tailor your documentation request to the person's work and to the kind of accommodation they're asking for. Next slide, please. Okay, so we said earlier, right, that an HR professional, that a supervisor might have knowledge of somebody's accommodation request, right? So coworkers, only coworkers who are directly involved have the need to know about an accommodation, right? Are gonna be sort of in the loop in an accommodations request. These are going to be potentially people who work really closely with that employee and may have to take note of that accommodation once it's implemented, right? So only the people who need to know should know about accommodations and whether they're going to be implemented and how. The confidentiality of this entire process is key. So while you want to be documenting everything, you also want to make sure that you're keeping your lips sealed and just talking to people who are going to be just directly impacted by this accommodation, only them. And that just goes to the idea that you want to create an environment, a work environment that is conducive to making people feel included, and you run the risk of alienating somebody who's asking for an accommodation by telling other employees about it who don't really have a need to know. Okay, so that's just something to keep in mind through this process. Next slide. All right. Okay, so we're on number 10 now. How can we make it work? So this is kind of just to recap kind of what we were talking about earlier. You want to make a good faith effort to accommodate people. So you want to make that effort and you want to document that you made that effort, right? And so this goes back to that due diligence that an employer needs to make for an employee when they're requesting accommodations. It's always a good idea to explore the accommodation ideas, to explore the different ways that you can help this employee be more effective, and then to document it, because later on, if you need to show anybody what was happening during this process, it's all there. You want to have a centralized accommodation process and an centralized accommodation function. So I think I heard Melanie say, that the university has an ADA coordinator. If this ADA coordinator looks at, the reasonable accommodations requests that are coming in from the university system or from your campus specifically, then that's a good idea, because it's centralized to the ADA coordinator and to her office. And you want to make the process known to all your employees. So you want to make it so that they don't have to look in so many different places to know, okay, how do is there paperwork that I need to fill out to request accommodations? Where do I get this paperwork? If you have an employee portal, you might want to post it there. But also just to let your employees know that the university is a place where we make people feel included and where they should feel free and feel empowered to ask for accommodations and to disclose their disability. I did want to touch on this last couple bullets right here on this slide that we're on right now.
Okay.
So you can have like a hierarchy of accommodation requests, because I understand that there are going to be some that are a little bit more complex than others. And this goes back to that individualized nature. So a lot of times larger organizations will have software that, they are recording people's requests for accommodation. And so if there's a way that you can prioritize, okay, we're going to be dealing with assistive technology requests first, then we're going to be dealing with shift or schedule modifications next. Like it's okay if your organization, if the university has a system in which you're prioritizing broad categories of accommodation requests. And this is so that you can be more expedient and you can get to the ones that are time sensitive, or, just however you want to prioritize them. But make sure you have a policy on that so that all of your people are aware, okay, this is how we're going to be dealing with our requests.
Okay, so we're going to Tom Haverford, and I apologize. We have some cool things that are coming through here on the slide. Tom Haverford from you might recognize Mr. Aziz Ansari there as Tom Haverford from the television show Parks and Rec. Tom Haverford, on accounts manager for the City of Pawnee Parks and Recreation Department, has long been diagnosed with a learning disability. Now, after working for the city for more than 2 years, he would like to request accommodations.
So if we go to the next slide, this is just to ask what kind of documentation would be like appropriate, or how the city, right? If they got any one of these 3 documentation types, which one of them would be the most effective or the most relevant? I kind of wanted to see if we could unmute you guys and see if anyone wanted to chime in.
Well, I think we kind of gave them the answers a little bit, because it's unfortunately on the Zoom platform, our answers are coming in there, Sashi. But
I see that. Yeah.
Melanie, I don't know if you guys want to unmute for comments from anyone.
Yeah, if anyone has any comments, that'd be good.
We'll give them a second.
So I should say the way that I sort of picked out these options was because these are things that we've heard across our technical assistance line. People have called us and said, hey, we have somebody who's requesting accommodations, and they were a Title II entity, and they brought in their high school 504 plan or their award letter from a standardized test, which may be sufficient at a certain time in their lives. But like Tom Haverford, because he's already been here for 2 years and far removed from high school or college, I don't think that's going to be the best indicator, those two top ones are going to be the best indicator for his needing accommodation. So the third one, which is actually specifically related to his job, that one is going to be just the most effective one for the time.
Okay, so the GMAT accommodation letter allowing for the extended time, correct?
Yes. So, it could go to his job responsibilities and the kinds of accommodations he may need, his GMAT award letter. But the problem is, like, it might be a little outdated. So you have to consider not only the kind of accommodation you're getting, but also, when it's from, who's giving it to you, or what source is it coming from. You just, they're kind of just intangible things that you have to consider when you get these sort of accommodations or documentation back to you.
And Sashi, I have a quick question. With regard to that last bullet point there, a doctor's letter recommending written instructions and further clarification as accommodations dated 6 months ago. Is there a time limit on those types of letters from a doctor? For instance, if the employer asks for it, the employee supplies it, can they ask, say, another year on down the line for like an updated or an update on this type of thing?
That's a really good question. So it depends. They could ask for it if there's something changed, right? So if they've noticed that the person may be needing additional assistance, or if the person's job tasks have changed, if the person got a promotion, there needs to be some kind of change, because all things considered, right? Like if the job has stayed the same, the employee's condition has not changed, there's no change in the job performance, there's not going to be a need to request updated documentation. But yeah, if things have changed noticeably, then it might be a good idea to have updated documentation. But before you ask for that, you might just want to ask the employee directly, hey, I've noticed this, or we've seen this. Is there anything additional that we can provide to you as an accommodation that would assist you in performing your job function?
And one last question or comment there. Does this go both ways, Sashi? For example, if something may not be, going right or gelling with, someone's getting an accommodation, but maybe the employer sees that, something, the work may be continuing to be affected, or does the employer have the right to still, intervene in that? In terms of with the employee, maybe if they feel like the work is still being affected by something, or maybe the performance is still not what expected.
Yes, ma'am, absolutely. This interactive process is ongoing, and it will continue for as long as the person is an employee there. And so that goes to creating that trusting work environment, where you do want to keep those lines of communication open, so that both the employee and the employer know that they can go back and reevaluate as things change.
Okay. So again, sorry, our little answers are coming in there. That was an unanticipated little thing there that came in there. But so Jack Bauer, illustrated. Special Agent Jack Bauer, formerly a member of the FBI's counterterrorism unit for a decade, has since retired from the Bureau. He is seeking a teaching position in various master's and doctorate level criminology programs. And there we have a picture of Jack Bauer, courtesy of our favorite Wikipedia, but Jack Bauer from the hit TV show 24.
All right, I'm going to the questions.
So Jack Bauer has severe PTSD and anxiety after his tenure with the CTU. Sometimes he's unable to be around large crowds and loud noises. He occasionally has panic attacks in stressful situations. He lands a job with a prominent public university in Washington, D.C.
All right, next slide.
So let's think about it. What are some accommodations for Jack Bauer as a working doctorate level professor?
So this is like a very outlandish example, but I really did. I just wanted to put this in there to illustrate that, you know, even people who are very experienced in their profession and have so many years under their belt and have so much knowledge and skill, they will come to you and request accommodations. And you probably have professors, you probably have deans on campus who may need some of these accommodations. And you have to really evaluate based on, you know, the kind of work that they're doing, who they're working with, and the need for their accommodations. So with Jack Bauer, right, because he gets these anxiety attacks and things like that when he's around a lot of people, an option might be that he does remote lectures where he might pre-record his lecture, or he might just like have a video meeting like on Zoom or Skype or something where he's just in a room by himself and he can deliver his lecture to a large classroom of people. You know, that's an option. Another option is that he has office hours that are pre-scheduled and by appointment only. So when I was in college and when I was in law school, we sometimes would have to sign up ahead of time for office hours with our professors, but sometimes they would just have their office doors open and they wouldn't have any defined time. You could just go in during certain hours and meet. So maybe if he had a system where he would meet with his students by schedule only, where he would know exactly what time they were coming, that might help him be more effective at being a professor, knowing ahead of time when somebody's coming in. This last one, extended leave time. Leave is an accommodation under the ADA. I should say it's a potential accommodation under the ADA. But what makes it reasonable, right, because it needs to be a reasonable accommodation, is that it is either for a definite amount of time, or if it's intermittent leave, that you know kind of how often it's going to happen, like the frequency of the intermittent leave. Indefinite leave, not reasonable, right? So somebody can't say, I need to leave for some time, but I don't know how long it's going to take me to seek treatment for this condition that I have. That may not be reasonable. It could be. It's just on the face of it, it may not be. And so in Jack Bauer's case, there might be some time where he needs to seek treatment intermittently, where he needs to meet with a therapist or a psychiatrist, or where he needs extended leave for like an inpatient treatment or something like that. So that might, you know, that might be a reasonable accommodation under the ADA under these circumstances. Just something to consider. Do you guys have any thoughts on this?
We're not seeing any questions in the chat area there. And
cool. We might go into the, I think we have one more slide.
Okay.
Yeah. Okay. So let's say the university claims that it's an undue hardship, or that it can't accommodate this. It can't accommodate Jack Bauer, right? So what kinds of things are they considering? So we had this like very broad list of considerations that we talked about earlier, right? Well, so some of the things that you would consider in this particular case is student performance, right? So how is Jack Bauer's extended leave, assuming he takes extended leave, how is that affecting the students' performance or their level of engagement in the class? Are they getting the same opportunity to learn that they would, you know, if he was if he had not gone on the leave. You would need to think about that. You need to think about what it costs and how inconvenient it is to hire an adjunct or someone else to replace Jack Bauer. So that would be another consideration to make. And also consider, how specialized is this position, and how soon could you fill that position if there wasn't a chance that he would be able to return, right? A semester goes by really quickly, and if he needed to take, 8 weeks or 12 weeks of extended leave time, well, how is that going to affect the university's ability to continue to offer this class and have someone teach it? So, just these are just three, but there's so many different things that need to go into the process of the interactive process, right? And documenting, the fact that there are these considerations being made and how they're going to impact the university. It's really key in the interactive process. Point out these three resources that we have listed. These are just three of the most important ones. The EEOC, guys, has just a wealth of information. EEOC.gov is their website. If you guys want to know about the accommodations process, go there. If you need accommodation ideas based on somebody's disability or their job functions or their functional limitations, the place you want to go is JAN, Job Accommodation Network. Just an awesome website. We use it all the time. So these are just three of the basic resources, but there's just so much information out there. If you have more specific questions, please give us a call, and we'll point you in the right direction.
At the ADA Center, there's our line, our information there. And I'm sorry, I did not mean to cut you off there, Sashi.
No, I was just going to say that. Give us a call, 1-800-949-4232, and we will answer the questions that you have more specifically, and if there are any relevant publications, we'll point you to those publications.